how does this case change that situation or that legal paradigm?
Well, I guess the short answer is I don't know yet, because this case is in such a narrow setting where the challenge was actually brought through the removal proceeding. And the issue really was about credibility determination. It's about fact finding. So we always learn from law school, it's just a hard case makes bad law. And I would say this is probably one of the cases where the question was whether the plaintiff, the petitioner rather, Patel, whether he misrepresented himself in his driver's license application by checking the box saying that he was a U.S. citizen. So at the end of the day, the immigration judge did not believe him that this was a mistake. And the Supreme Court basically said that reading this provision in the INA, it's a discretionary decision, and the law said that we don't have jurisdiction to review any decision regarding this adjustment of status application. So from this decision, it appears that the door is shut on the agency's fact-finding. But of course, it remains open for any challenge on due process, constitutional issue or a question of law. And now, the court did not specifically address the argument that this decision may shut the door entirely on district court challenges. But the court's attitude was, we are not going to address this, but even if we were to address this, too bad. We don't really care, because that's what appears to be what the Congress intended for. And we don't want to talk about any policy decisions. So I foresee that it may just get tougher in the district court challenges, but it depends on the government's attitude, because the interesting thing here in this case is that the government actually took a similar position almost with the petitioner. That is, the court still should have, the district court should still have limited jurisdiction to review certain fact finding. And certainly, in Judge Gorsuch's dissent, he mentioned this long established principle that question of law is not in the vacuum. Mm-hmm. Question of law involves applying the law to a set of facts. So even if, let's say, we no longer can challenge the fact finding, we can still challenge how the court applies the law on this set of established facts.
Right. The Administrative Procedure Act says that if under, I think it's 706 subsection 2, that if the government reaches a conclusion that's arbitrary, capricious, not based on the facts in the record, even if we're not arguing about what facts are there, if no reasonable fact finder could reach that conclusion, then a U.S. District Court can overturn that. And you were talking about the government not agreeing or not taking as hard a line position. I found it very interesting that the Department of Justice, representing the government, argued, as you said, they argued that there's some reviewability left there, but the U.S. Supreme Court didn't agree, and they appointed an amicus brief writer to represent a much harsher legal position, and then they adopted it. So the petitioner in this case didn't request this outcome. The government didn't request the outcome, but the court found a lawyer that would write the amicus brief to give them the position that they wanted to ultimately find. And Justice Gorsuch in dissent says this is tortured logic and reverses decades of American jurisprudence. So I will be interested to see if future cases, if Justice Gorsuch is able to convince one more Republican appointee to come over and make it a 5-4 majority to not increase the scope of this precedent that we have here now. And Justice Amy Coney Barrett wrote the majority. It's a 5-4 split, so it's just barely precedent, but it will be interesting to see how it's handled in the future. Do you think this would be applied outside of the deportation removal context or outside of the I-45 discretionary context?
I think it's possible, and it really also depends on whether the government is going to use this weapon to the fullest extent possible. Because this case has been so new, we have not heard any examples of the government starting to submitting 28J letters to try to get out of the district court. But I expect that in a different administration, this is completely possible.
Sure. So if I understand you correctly, basically you'd have an assistant U.S. attorney or a Department of Justice oil attorney in a case. They'd be looking at the facts, looking at the law, and say, well, we have this new precedent now. I'm going to go ahead and file a motion to dismiss saying that there's no jurisdiction here. And then the lawyers will argue, a judge makes a decision. You might have U.S. District Court judges granting motions to dismiss. Those could be appealed up to the circuits. The circuits may come to, well, we have 11, 12 circuits. So we may end up having different decisions coming out of different circuits. And then the question is whether it ever gets back to the US Supreme Court to be ratified, extended, limited, et cetera. So it may take a couple of years to see how this kind of shakes out.
Yeah, I agree. But in the meantime, I guess for those cases where you think district court remain a good option before this decision, I don't see any reason why not to just try it, because there's always the possibility that a U.S. attorney reads the agency decision and says, I just can't defend this. Even if you have the fact-finding power, it just looks bad.
Absolutely. And if you ultimately want to take down the Supreme Court decision, the way to do it is to find the most egregious factual violation possible, and then bring that in a liberal, circuit. And the Ninth Circuit isn't exactly liberal anymore, but you need to look at the courts where you think you might have the right panel to review it. And you also, when you're filing your lawsuits, they use a lottery system to assign to district court judges. So you can't exactly say, I'm going to file my lawsuit and I'm going to get Judge so-and-so. But I've done some litigation in Vermont. I believe they have 3 district court judges. So if you're in filing this lawsuit in Vermont in the Second Circuit, if you have a 1 in 3 chance, or 1 in 2 or 3 chance to get a more liberal judge. So you kind of have to, you were saying bad facts make bad law. Here, bad facts might undo the bad law, but you have to be very careful about how you bring it up through the courts, so that way you don't actually get the opposite result. But I agree with you. In cases where I think that settlement might be possible, I bring those lawsuits. And when they aren't possible, I tell my clients ahead of time, I manage their expectations and say, hey, we have a 50-50 chance, less than 50-50 chance.